Part 8 is the use of force. We're going to discuss common law again, the belief of imminent attack, Section 3 of the Criminal Law Act of 1967. All alternatives must be explored before force can be used. To make the use of force unlawful, report unlawful use of force and get crime reference report to the IPCC if they refuse to give a crime reference number, and follow-up investigation report to the IPC if no action. Take to court if further action is taken by the police. So, starting with you, then get Mark over on to the common law.
Yeah. Now, R versus Howell refers to another case, Beckford versus the Queen, 1988. That there defines the test, which is basically it's about self-defense. Nobody has the lawful right to instigate the use of force. It's always a position of self-defense. And the test is that a person may use such force as is reasonable in the circumstances as he honestly believes them to be in the defense of himself or another. So, just really reiterate, it's about self-defense. Nobody has the lawful right. So that comes down to belief of what is an imminent attack. And again, that's defined in the common law. A person may use such force as is, and it's objectively reasonable in the circumstances, as he subjectively believes them to be. Now, remember, it becomes a fight-or-flight situation, and so the reasonable is not a very clear, defined thing. It's about the honest belief of the self.
Yeah.
So if the defendant genuinely believes that an attack is imminent or underway, it does not matter that they were mistaken in their belief. And that there allows for even preemptive self-defense. So that's defined in another common law case, R versus Beckford, where a man is about to be attacked, does not have to wait for his assailant to strike the first blow or fire the first shot. Circumstances may justify a preemptive strike. Legally, so now the Criminal Law Act 1967, it does say a person may use such force as is reasonable in the circumstances in the prevention of a crime, or affecting or assisting in the lawful arrest of offenders or suspected offenders or persons unlawfully at large. So you can see the difference between the common law and legislation. Legislation, they talk about reasonableness. However, the common law is common sense. I am the only one that can assess the reasonableness of the situation at the time. However, we're all under a lawful obligation to explore all alternatives before force can be used. And this is from the police.
And that applies to both sides?
Both sides, absolutely. So these are the tests that the police must go through before they use force. So the first thing is, would the use of force have a lawful objective, i.e. to prevent injury to others or damage to properties, or affecting a lawful arrest? The next question they need to ask themselves is, how immediate and grave is the threat that's posed? And then the next one is, are there any means short of the use of force capable of attaining that lawful objective that's been identified? So it's a very clear procedure the police must follow before they actually go through it, and but that's because they're using it preemptively, so it's slightly different. So hence they have to have regard to the nature and gravity of the threat and the potential for adverse consequences arising from the force, i.e. if we do use force and start instigating force, what are all the consequences? And those include, they need to evaluate the risk of escalation and exposure of others to harm. What's the minimum level of force required to attain the objective identified? And would the use of that level of force be proportionate or excessive? So this is what the police must go through. And this is because, like I say, from a preemptive viewpoint, but even from a reactive viewpoint, so they cannot use just whatever force they like. So, very simply, to remove the lawfulness of the use of force, simply stand back, hold your hands up, and say, I will comply with your commands under duress, and therefore you have no lawful excuse to lay a finger upon me. So you're telling the police, you're fully aware of your rights, and you're telling them that you cannot touch me. Now, remember, what this is now, you've given an undertaking. So if you do not comply with any of their requests from then on, you now have given them lawful excuse to use force.
And the use of handcuffs is just another form of intimidation.
Absolutely, absolutely. In any type of force is intimidation. Remember, guilt is determined by the courts, not by the police.
Sure. And
it's about one person laying a claim against another. So should they use force despite you giving this undertaking, you simply say to them, I've said I will comply with your commands under duress, thereby removing your lawful excuse to as much as lay a finger on me. Your actions are battery and I will be reporting your crime to the police. So again, we reinforcing it. So then we go through the same stages, create your record, report the crime to the police. If they don't record it or follow up on it, then you go to the IPCC so that you've got the pre-action protocol ready to take them to court to hold them to account. And so this same procedure could be applied to a security guard in a nightclub, or if a landlord won't let you into a pub or whatever. So it doesn't matter, it applies everywhere. It's the same procedure. So not necessarily just for police. So that covers the use of force and how to take away the lawful excuse. And remember, if they do not withdraw, or whatever the correct word is, if they act unlawfully, then you have a right to sue. It's breaching your peace, and each stage is a separate breach of peace. It's not just the worst one that counts.
Yep.
All of them count individually.
Okay. Good. Thank you.
Okay.